So, some of you asked me early on how I ended up becoming a lawyer. Uh, and so I tell this in my ethics class when I talk about character and fitness. I mentioned a story, but I'll just briefly describe it here. So I was in my 30s. I had just gotten out of a large business, some positive, some negative. And I realized that I got to my 30s without really focusing on myself. I always did things to take care of my relatives and family members. And so this time it was different. I'm like, well, I got to do something for me. And so I decided at that point, and I was sitting in my man cave. I was wasted. I don't drink anymore, but I was wasted at that point. I literally, and I had built this 500 square foot man cave in our New Jersey house, which we don't have anymore. And I literally flipped a coin and heads, law school, tails, medical school. And just out of curiosity, I took the practice MCAT. And I scored pretty good on it, shockingly. But as you can imagine, I'm a lawyer now, so law school is what won. And so sometimes in life, we take chances, and if we've prepped enough, if we've crossed our T's and dotted our I's, those chances end up becoming great rewards for us. Now, I know a lot of you have first generation or second generation lawyers, never even thought about becoming a lawyer when you were younger. But kudos to you. I mean, think about it. You are 2 L's and 3 L's. So, a very small fraction of you, graduated high school, at least where I'm from, hardcore streets of New Jersey. Very few of us graduated high school. Very few of us went to college. And even less of us went to law school or professional trade school. In fact, I don't know really anybody from my high school that went on to become a lawyer. And so the point I'm trying to make is that the fact that you're here speaks volumes about you as individuals and characters in your own stories, right? So keep it up. I know sometimes it can get difficult, but the point is, put your head down, get the work done, and just keep pushing forward because this is for you. Don't do this for anybody else. All right, so we talked a lot in our previous classes about debt defense. We talked about bankruptcy. We talked about Chapter 13. We talked about Chapter 7. We talked about emergency bankruptcy. And now we're going to talk about foreclosure defense. I'll keep it short and sweet. So your client calls you and says, hey, I have a foreclosure action that was being filed, right? That has been filed against me. I just got served last week, and I've got 20 days to file an answer. And so at that point, your brain is, the hamster in your head is turning. And you're thinking, well, Chapter 13 might be a great option because if you're behind on your mortgage, you could, in theory, bring your payments current. The hamster is also spinning and saying, well, maybe you could do some sort of a forbearance action. Maybe you could do a right of redemption. Maybe you could win the lottery. I don't know. But there is another option that we haven't talked about, and that's called foreclosure defense. And now this doesn't always work, but it is a great option for folks in very specific scenarios. So foreclosure defense is where you file the pleadings to stop the foreclosure to go into default. It buys your client a bunch of time. Now, the question is, why would you want your client to be bought a bunch of time? Imagine this. Your client has a buyer, somebody who's interested in buying their property. It's going to take them 2 months to close on the house. And so for those 2 months, they can't pay their mortgage. But if they don't answer the complaint, then, well, I see a lot of you nodding your heads because now you understand. What you're essentially doing is filing documents to buy your client time so that they can sell the house, do the right of redemption, which pays off the mortgage, and walk away with some profit. So that is option 1. Option 2 is your client comes to you and say, listen, I'm going to move into an apartment. I don't have the cash right now to put down a down payment on an apartment, or my credit isn't the best, or I'm going through a relationship situation, or I'm moving out of the country or out of the state. I need to stay in this house for as long as I can. And so this is a tactic. We call this cash for keys. I know it sounds crazy, but think about it. You file the pleadings. Your client hires you for foreclosure defense. Your job then becomes to buy your client as much time as possible to stay in that house for free. Free is the wrong term, but you get the idea. Your client pays you to file 3 or 4 or 5 documents with the court. The discovery process can last months. In that time period, your client's very likely not going to pay the mortgage. The mortgage company probably won't even accept it because it's in foreclosure. So then at the end, what you do is you negotiate with the opposing counsel for cash for keys. Think about that. The mortgage company is going to pay your client to move out of the property without causing damage. I'm going to say that again. The mortgage company will pay your client to move out of the property in peace. Don't steal the fridge. Don't steal the pipes. Don't steal the electrical, copper wires or whatever they're using nowadays. They're essentially saying, leave the property and we'll pay you for moving expenses, or we'll pay you for the inconvenience. I have done this in the past. It's only happened like 3 or 4 times in my career, but when I worked at a firm here in downtown Orlando, I was able to get, and I'll never forget this, $2,000 for my client, a check for $2,000 for my client, 60 days after he moved out of that property. He got to stay in that house for 18 months without making a single mortgage payment. And afterwards, the bank still gave him $2,000 to walk away. Think about that. That's a win. We charged that client $2,500 for foreclosure defense. That was back in 2020 or 21, just around COVID time. And so you can do that. You can buy your client a bunch of time to stay in that property without making mortgage payments. Now, you might think that's wrong. And yes, in some ways that could be wrong. But remember, your goal here is to give your client the most advantage that you possibly can. And as long as you're not doing anything unethical, as long as you're not doing anything illegal, then you're perfectly fine and your client is perfectly fine as well. It's called foreclosure defense. And so the way it works is, the way we do it is just like debt defense. We'll file 3 documents with the court: notice of appearance, designation of email, an answer. We'll request discovery. The other side will request discovery, and that process can take months. And in that time period, your client can figure out what they need to do. Either they'll figure out how to get the money and potentially reinstate the mortgage, figure out how to get a lot of money and do a right of redemption, or cash for keys, or potentially a Chapter 13 bankruptcy. So it gives your client breathing. That's the way I look at it. Questions, comments, concerns? Nope. Afterwards, thank you.